Okay, so another key term is this one that I've used a number of times, the reference to state. Just want to make sure that you're very clear that when I'm talking about a state here, I'm talking about a nation or a territory that has organized political community under one government. So in most cases, I'm going to be referring to nations as opposed to individual states that together form a federation or a commonwealth. So we have individual territories within Australia that we call states. I'm here in the state of Victoria. Actually, this is a face-to-face class, so most of you should be in Victoria, but maybe some of you are still in completely different states. That could be states of Australia, or it could be other nations. So here we're talking about a state in the context of sovereignty. And for the most part, I think it's better for us to be thinking about countries, even though a country like Australia is made up of individual states and territories that have individual lawmaking powers, as well as the powers that are imposed by not imposed, the powers under the Constitution of the Commonwealth to make laws about those matters that the Constitution reserves for it to make laws about. Again, we don't need to get ourselves too wrapped up in this, but just recognise when you're used to talking about a state to mean Victoria or New South Wales, think about state as quite likely meaning a nation like Australia, the US, China, Ukraine, etc. And why is it important to talk about states? Because ultimately it is states that have, the next term I want to talk about, sovereignty. So sovereignty is effectively the power that a state has to govern, in other words, to make laws. So sovereignty is the source of the jurisdiction to prescribe. To enforce those laws over people within its territory, and also to enforce laws or to make laws about its citizens outside its territory. So these are ultimately the jurisdiction to enforce. Thirdly, sovereignty really is where a state has its power to investigate, detain suspects, require evidence to be given in a court, to require submissions to court proceedings. In other words, its jurisdiction to adjudicate. So the principle of sovereignty is that all states are equal and independent and hold the highest authority within their own borders. And this is a fundamental principle of international law. So if a state is asserting jurisdiction over another territory, that is an attack on the sovereignty of that other territory, which is ultimately why this problem of jurisdiction over the internet is such a big deal. Now, the term territory is one that keeps coming up again. Again, you might be tempted to think of a territory as being a part of a country that doesn't have the full rights to be a state, like the Australian Capital Territory, for example. But in this context, we're really talking about the space within a state's physical borders, an area of land that is within the jurisdiction of a state. So this all brings us to the territoriality principle. As Cormier says in the reading that you have, at its core, a state can exercise prescriptive, adjudicative and enforcement jurisdiction over conduct that takes place in its physical territory. In other words, if someone shoots a gun and that gun goes into the heart of somebody in the same state, then the state will have jurisdiction over the consequential matter. So on the assumption that murdering somebody is a crime in that state will have the jurisdiction to investigate the crime, to charge the accused, to hold a hearing in its courts or tribunals, to require that person to attend the court, to deal with the evidence that it collects in the way that is consistent with its laws. And at its core, that is one of the things that makes a state a sovereign entity. So that's objective territoriality. But if we have subjective territoriality, that's when we start to ask questions, well, what happens if, for example, and I'm using the example that Cormier uses in the readings, if someone shoots a gun, but the bullet crosses that state's border and hits somebody in another territory or in another state. So the subjective territoriality principle provides that a state has jurisdiction over an action that commenced within its territory but was completed somewhere else. So that is also referred to from time to time as subjective territoriality, or the origin approach. So the state where the action originated has jurisdiction. But then we have the objective territoriality approach. So where, same set of circumstances, somebody has shot a weapon across a state border, the state that the state in the place of origin where the action originated has jurisdiction, but where a constituent element of a crime has taken place in another territory as well, the state which is responsible, has jurisdiction over that territory, can also assert jurisdiction. So we call that the objective territoriality. And I think you can already see how then we end up with a situation where, in that very simple example, the act of firing the weapon in one state might be entirely legal because, let's say, it was shot by a soldier and there's a border dispute. So then the law, in the laws of one place, that particular person who shot the gun, they're not in any trouble whatsoever. In fact, maybe they're getting a bonus. I don't know. I should not take my examples too far. But in the other state, it is seen as murder, that this is not a sanctioned state affair, and that so the laws of that second state would seek then to hold the person who shot the weapon accountable. And already we've got an issue because to what extent does the first state need to recognize the requirements of that second state where the constituent element, the actual injury, took place? We also have what is called the effects doctrine, and Cormier talks about this as well. So under the banner of this territoriality principle, we have this effects doctrine where a state can assert jurisdiction if the economic effects or other negative consequences of an activity that are conducted outside of the state's territory are experienced within its borders. It can claim jurisdictions. So for a very long time, the effects doctrine was used really extensively by the USA in what's called antitrust litigation. So in particular, it was seeking to collect copyright payments and royalties in relation to the goods and services and intellectual property of its citizens that were being dispersed around the world. The territorial effects doctrine has been repurposed for a range of different uses in jurisdictional claims in relation to cyber disputes or internet disputes. Both the objective territoriality principle and the effects doctrine have sometimes been repackaged as a destination approach. Remember the origin approach I mentioned earlier? And so this is the way that by calling it the destination approach, it's a way for jurisdiction or the prioritizing of jurisdiction to be given to the state of the destination in cross-border matters. So read Cormier for some more detail here. And I think that as you start to think about the internet and the way that the internet can be regulated, just as the first of the kind of technologies that we're going to address, can see the complications that will arise. So just a quick update. Jurisdiction and regulation, we're on top of those. We've now talked about what states are, we've talked about sovereignty, we've talked about territory and the territorial principles. So let's actually move on to the next 4 of those jurisdiction principles quickly, so that you can understand the extraterritorial principles. So ultimately, states can't exercise their jurisdiction outside their own borders unless one of these exemptions applies. And so these are the 4 so-called extraterritorial exemptions. So a state can exercise jurisdiction over its own nationals. A state can assert jurisdiction over crimes that take place outside of its borders, where one or more of its nationals are a victim of those acts. Let me give you an example. A current example is the actions that are being taken by Australia and other nations in relation, and Malaysia, in relation to the shooting down of a Malaysian jet over the Ukraine some years ago. So the plane was a Malaysian plane, a Malaysian Airlines plane. The weapon is reportedly a Russian weapon. It was fired in the Ukraine or thereabouts, and the plane came down over the Ukraine, and a number of people were killed, including some Australians. We also have what's called the protective principle. So this allows a state to assert jurisdiction over extraterritorial acts of non-nationals where they threaten national security or key interests. So a really good example of this is sanctions legislation that's been brought in all over the world in the last year to prohibit banks from allowing Russian nationals to move, or Russian oligarchs in particular, to move money around from one place to another, even though they are not Australian citizens. Australian banks are not allowed to move this money around because of concerns about that money being used to finance the war in the Ukraine. And then we have some universal principles. Now, these are pretty rare. So essentially, the international crimes of genocide and other crimes against humanity. Oh, excuse me. Oh, sorry about that. So these are really only used in very limited circumstances, and relate to particularly serious international crimes, including genocide, crimes against humanity. We might think about these in relation to the ways in which the internet has been used for crimes against children, for example. They may well be seen as serious enough crimes to fall under that universal exception. Let's finish that with this one from here. There's going to be a couple more short videos with some important contextual material, but as always, questions, concerns, comments, compliments, do not hesitate to ask me.